their assets, there's a large gap there, right? Because estate planning covers people who are alive with capacity. Well, what about alive without capacity? And that's exactly the gap that conservatorships can fill in. Trust administrations can also fill that gap and generally should if an estate plan is done. But there are scenarios where where a estate plan and the trust fails, and a conservatorship is still needed. This is usually the situation where a person, usually with dementia, but somebody later on in life with dementia, who is having issues controlling their own assets, is being scammed, probably, and doesn't recognize that they have deficiencies. Right? That's a scenario where their estate plan and their successor agents may not kick in because they're not willing to give up control. I still know what I'm doing. Why would I go to a doctor to get checked out? Why would I get an incapacity letter when I know perfectly well what I'm doing? Right? Those are situations where conservatorships can pop up, even with a perfectly executed estate plan. You'll also notice I have a very few slides this week. I have a lot of background, and that's kind of the reason for that. So in another way, protective proceedings. So a more focused look at this certain umbrella. So overarching, you have your protective proceedings. Under that, there's guardianships. Guardianships are for minors, so anybody under 18. If they have lost both their parents, presumably, potentially they need a guardian, or if they inherit money directly into their own name, potentially they need a guardianship of the estate. That's not our focus today. I'm not going to talk about that much, but that's just a general umbrella. Conservatorships right there in the middle, that's where I'm going to focus today. But on the other side, there's something called care proceedings. This is a new development, and that came about, I believe, in 2022 is when the law passed. But the implementation actually has already started in a couple of counties. I'll talk about that just briefly. The idea of care proceedings is to provide an avenue for people with mental disorders. So think schizophrenia, bipolar, kind of things like that, mental illnesses, to provide an avenue for them to maintain dignity, to be able to make choices on their own, but to still get them the care that they need. I have my doubts on whether the system will work or not, but we'll talk about that a little bit. Then under conservatorships, we'll talk about 3 types, and I'm going to focus on 2 of them today. The first one is called an LPS conservatorship. The Lanterman-Petrus Short Act is what created this type of conservatorship. That's why it's called an LPS. Those are the 3 guys, right? The 3 senators or House Assembly members. I don't exactly remember which, but these are designed to take care of people with mental health disorders, so mental illnesses. I am not going to focus on these, largely because as practitioners, we don't have any control over these. These are initiated generally by the public guardian and by the county, and it's usually for situations where there's already some sort of psychiatric hold. So they're in the hospital, 5150 holds you've likely heard of, things like that. There's limited conservatorships. Those are meant for people with developmental disabilities. And then there's probate or general conservatorships. Those are meant for people usually later on in life who've lost capacity in one way or another. So dementia is your normal case, having a stroke, in a coma, just memory loss, things like that. That's all included under that umbrella. Any questions regarding that? All right, so let's start by, I'm just going to give you a brief summary of each of the types of protective proceedings that I'm going to focus on today. I will say for LPS conservatorships, I get a lot of people calling, and it's usually a parent calling for their child. You know, their child is 20 years old, 30 years old, has had schizophrenia or just developed schizophrenia or bipolar, is now, in their words, right, going crazy. They are running out on the streets naked. They don't want help from anybody. They're living on the streets. And they're on drugs and they won't get off drugs. Drugs is kind of a weird topic. I'm not going to focus on that today, but that does come up a lot, even with mental illnesses. So they're looking for help for their kid. You know, what can I do to help my child? From a practitioner perspective, I give them what sounds like absolutely awful advice, and I hate it absolutely every time. I can't help you. Your best way to help your child is to let them fall as hard as they can so that the system picks them up and they get help. And I always tell people, you know, as a parent or as a sibling, whatever that relationship may be, there's an ethical dilemma there. And I see it, I get it, right? Can you actually let that person fall? And let me talk about that a little bit. The background here, right? It's defined by the Welfare and Institutions Code, not by the Probate Code. It's established for somebody who is gravely disabled. That terminology is kind of fuzzy within the law. It can be argued in many ways, but generally means they are on a hold of some sort. And then chronic alcoholism can come in. I have not really seen those cases, largely because I can't practice in this area. A person is not gravely disabled, they can survive safely without involuntary detention, right? So that's with the help of other supporting members of their village who are willing to do so. So essentially, with that definition, if family members will step in and will take them in, they no longer fall under that definition. That's the hard part, right? So if you're in a hospital, they need to get discharged. A family member comes and picks them up and is willing to do that. The county says, off our hands, not an LPS conservatorship. And I'm not putting any blame on the county by any means. They are under-resourced like absolutely every other government entity. They don't have the resources to take these cases up. But it's also in the codes, right? They're supposed to do this. So there's this kind of mismatch of what should happen and what they're funded for. It is an extension of a 5150 hold of some sorts. The cases generally get from the hospital to, and it's referred to the public guardian. Public guardian then filed the case. The public guardian is a government entity that serves as a conservator. They sometimes can serve as like an executor as well, but usually they're serving as a conservator. Their name is almost kind of exactly what it sounds like. It's for the public and they take care of people. There's technically no limitation on who can file, but I have not found a practitioner willing to do it for a couple of different reasons. An LPS conservatorship can force medication on somebody, but you're really controlling somebody's life, like actively controlling somebody's life. They're designed to be very short term. The problem with mental illnesses usually is if somebody who is bipolar, schizophrenic, whatever, gets on medication, all of a sudden they have capacity again. They're doing just fine, right? That conservatorship then goes away. They then repeat their cycle. They choose to take their medication. They go back off, right? So that cycle just repeats itself. It becomes a very difficult scenario. Any questions on that? Yeah, Karen.
So because of that cycle, would you then recommend for them to apply for just a regular conservatorship?
No. And the main reason why, which I'll get into in just a second, but under a probate conservatorship, you cannot force psychiatric medication, right? So you have all the duty and responsibility to provide care for them. But what most parents want and most family members want for them to go back on their medication, because that's what stabilizes them, right? If you can't force that, what's the point? You get responsibility without the real teeth behind it that you want. We have had cases where parents decided to move forward regardless with a probate conservatorship and ended up a couple of years down the line deciding, we can't do this anymore because they're constantly handling that same cycle. Any other questions? All right, so probate conservatorships, this is where I'm going to spend the majority of my time combined with limited. General case, dementia, strokes, old age, I already briefly mentioned that. Defined by the probate code, I already mentioned that before as well. Essentially, you're unable to care for yourself or unable to resist undue influence. There's many cases on the undue influence side. A common example that I like to use is we represented the conservator, but it was a conservatorship of both a husband and a wife. What was happening is they were convinced that they had won, I believe it was the New York lottery or something like that, but that they were actually going to get delivered a car as long as they provide extra money, right? So every day, every couple days, $5,000 sent out to whoever this person was, the scammer, $3,000, $4,000, whatever. The gentleman waited outside of his house every day in a suit and tie, waiting for delivery of his car. We represented a professional fiduciary in that case. The county actually requested that our client petition, and we were appointed as conservators and kind of resolved that situation. But these are the types of situations where people are unable to resist undue influence, right? You talk to him on a normal person-to-person basis. He sounded just fine. He sounded like he knew what he was doing. Another case very similar, was giving money away and things like that. I asked him, I actually talked to him directly and said, do you know that you're being scammed? Yeah, no, I definitely know that I'm being scammed. But I just need to give them an extra $2,000, right? And then I'm done. That's the last I'm going to do. And just keeps on repeating, right? That is definition of unable to resist undue influence. They know it, but they can't resist it. Again, this is why I like conservatorships. These are people who need the help, right? The assumption, with a general conservatorship, what happens if it's granted? There's an assumption that they no longer have the capacity to do anything except for, and this is going to be a definition difference with the limited conservatorship. So weirdly enough, the law has carve-outs for voting and for the right to get married. Even if you are conserved, you have the right to get married. So a lot of the stuff with Britney Spears, where she says, they didn't allow me to get married. I don't know whether those powers are granted or not. That's not default within a conservatorship. The right to vote as well. They have, as long as the person can express a desire to be a part of the voting process, they can still have the right to vote. It doesn't mean they have to understand what they're reading. It doesn't mean anything else. As long as they can say, I want to vote, they can vote. So just an understanding there. However, they're not able to legally enter a contract, right? So they can't hire an attorney necessarily. So is this a bit of a mismatch? Probably. But it's designed to protect civil rights, right? So the idea is marriage is so sacred that they're going to protect it. Whether that's right or wrong, not for me to decide. That's what the law currently is. Any questions on that? Yeah.
You kind of mentioned this before, but what about the pregnancy if the person wants to have a baby or even
So the question is, what about a pregnancy or having a baby? There's no limitations within the conservatorship for that. There potentially are within a limited conservatorship, which I'll get into right now. So thank you for the segue. All right, so limited conservatorships, baseline, you're talking about autism, Down syndrome, you're talking about things that people are born with, intellectual disabilities, cerebral palsy, right? Those are all things that come up. They're called limited because it's assumed that the person who is conserved, it's assumed that they have ability to do everything except for, right? So the flipped assumption of a probate conservatorship. You then carve out powers that they're no longer able to control for themselves. And those powers are generally assigned to the conservator. There is technically the ability to carve away powers without assigning them out. I don't really know what the purpose of that would be, but you can technically do that. There are generally 7 powers that are given to a conservator or can be taken away from an individual. So I listed them there. I will talk about that briefly. The residence, so ability to decide where you live. Usually that's not an issue, right? Because usually the conservator is willing or the conservatee is willing and able to let their parents help, let their sibling help, right? Figure out where they live. Confidential records, so that would be access to medical records, school records, things like that. The ability to contract, right? So whether you can enter into a contract of your own, that does affect things like buying a car. I am working on a case where our conservatee has purportedly signed multiple contracts for solar panels on her house. Those are by law void, right? Because she no longer has that ability. That's not under a limited, but just a general concept. Medical consent, right? So whether you want to have a procedure done or not, that power can be taken away and given to somebody else. That could, Shayla, to address your question about, giving birth, if you're looking at an abortion or things like that, that would potentially fall under the conservator's powers. Education, right? So where you go to school, things like that. If you're going to go to school, that's a decision for the conservator. A lot of times that will come into play because your conservatee is now aging out of the school system, right? They're now 19, 20. There's adult day programs and things like that. They need consent to be able to get into those, right? So that's where the conservator would consent. The right to marriage. So you'll notice this one is this time can be taken away from the conservatee, right? So a little bit different because your type of person that you're dealing with is different. The level of this is usually somebody who is so intellectually disabled that they cannot understand what they're doing. And then this last one can be controversial, and it's the right to control social and sexual contacts, right? So you can control visitation, you can control from a practical perspective, the right to control sexual contacts is nearly impossible to control, right? If you have an adult child who is sexually active, who's going to go around, how are you going to stop them, right? What this brings in, though, is they presumably, if the conservator has this power and it's been taken away from the conservatee, if they have sex with anybody, it's presumed rape, right? Because they have no ability to give consent. I've never really seen this pressed anywhere, but that would be my argument if I were to go that way. There's a entity called the Regional Center. Are any of you guys familiar with the Regional Center? Okay, so there's a handful of people nodding or shaking their heads. The Regional Center is an entity created by California law. It is only in California. I believe there's a handful of other states that have similar entities, but it's designed to provide free care for people with developmental disabilities. This was all started and funded by a guy, I think, who had children with developmental disabilities and who was in the state legislature at the time, right? So he threw a whole bunch of money this way. It's fantastic in the sense that most other states don't have anything like this as a public resource, but you can essentially get rehabilitation, you can get therapies, speech therapies, you can get day programs, you can get respite care, you can get a lot of things as a parent through the Regional Center. That's all that to say, they are very involved with the conservatorship process. They are required to get notice because one of the requirements of a limited conservatorship is that the conservatee is a client of the Regional Center. So they have to be involved with that in some way or another. The Regional Center has a relationship with them, so they are required to provide a report to the court for a limited conservatorship on whether they think it's warranted or not. The Regional Center, by statute, is designed to help individuals be as independent as possible. For that reason, these 7 powers that I've listed here, the Regional Center almost always objects to the right to control marriage and the right to control social and sexual contacts, right? Because they believe to help an individual grow, they need those abilities for themselves. The court will often overrule that, just because as a practical function, can these people really make those decisions or not? That's more of what the court is looking for. Again, there's a strong desire to promote independence. That's the whole point of this. There's a whole movement towards something called supported decision making, which is essentially if they have enough capacity to sign contracts and things like that, them and their village around them come to agreements on what help they will receive and things like that. Otherwise, there's ramifications, right? If it doesn't work out and they don't cooperate, potentially they have agreed to a conservatorship. The idea is that they are part of their own plan, right? That's the idea behind supported decision making. I have not done it myself. I haven't really worked with that, so I can't give you too much, but that's the concept. Yeah, question.
So on the sub-powers, including residents, is the goal to keep them within the county that the conservatorship is established? Or can a conservator, I guess, move someone to a different county, different state, and how would that work?
Okay. So the question for those of you online is, how does the residence power work? Is it designed to keep people at home or in the county that the conservatorship was started in? Kind of how does that all work? The straight answer to your question is no, it's not necessarily designed to keep people where they are. Within the probate code, the conservator can move the conservatee anywhere within the state of California without court permission. That includes to a group home, that includes to, if they move somewhere, potentially they move with them as well. Potentially you would have to transfer the conservatorship, the case to wherever they move to. I did not mention this, but a conservatorship does have to be filed in the county of residence for the conservatee, right? So if they live in Alameda County, it gets filed in Alameda County. They move to San Diego, the conservatorship should get moved down to San Diego County as well. You do have to apply for permission to move things out of state. There's a process for transferring a conservatorship, which is fairly ridiculous in my opinion, but the idea is both courts weigh in, right? So you have to get a provisional order to move, then you get a provisional order to accept, then you get a final order to move, then you get a final order to accept on both sides, right? So it bounces back and forth between the two courts, and it takes a total of somewhere between 4 and 6 hearings, something like that, which is expensive, right? That's kind of the problem with it. The idea is that they've matched the laws, they make sure all the powers are covered and same things like that. Does it always work? I don't know. You never really see it on the other end, so it's hard to tell. But there is a process for that. I actually have a client right now with limited who is looking to move to Montana. They're in California, right? So we're dealing with that currently. Any other questions on the limited conservatorship? All right, so the CARE Act, I was right, to 2022. The idea behind the CARE Act was to provide kind of an in-between avenue for those people with mental illnesses. So we briefly mentioned the LPS conservatorship. You saw kind of how restrictive that was, and the abilities to get an LPS conservatorship is also very limited. The idea behind the CARE Act, I cite the Welfare and Institutions Code there. The idea is there's a procedure to provide kind of like that supported decision-making I just described for disabilities. The idea is to provide that for people with mental illnesses. But essentially, a petition can be filed with the court to start a care proceeding. And then you go through a series of, these are kind of the requirements, right? You have to be 18. The conservatee has to be at least 18, experiencing severe mental illnesses, not clinically stable. So they're not on medication, essentially. Unlikely to survive in the community. They're able to participate in a care plan, and then the person is likely to benefit. The concept here is through the court process, they get assigned therapists, they get assigned different people who are advocates for them and things like that. But you're working with the person who petitioned, usually a parent or something like that, and you're working with the person with the mental illness. They're supposed to work together to create a plan where everybody agrees that they're going to take certain steps to take care of themselves. A major problem I see is they're not clinically stable, and that's a requirement for this care plan. They're not clinically stable, they're going to have a very difficult time agreeing to a plan and sticking to that. Whether this works or not, it's just being started. The initial law started in October of 2023. So we're only a couple months into this, and it only started in, I believe, 3 counties. One of them is San Francisco. I have not heard anything about whether this is working or not. We'll presumably hear something soon, but who knows? And then all other counties are supposed to start by the end of this calendar year, so December 1st. Right? I have not heard too much about the implementation of this, even within our own counties. I don't know what this is going to look like, but presumably it's supposed to start. Again, my problem with it, it's a voluntary agreement. Number 2, there's no ramification. If the person doesn't follow the care plan, it just goes away. There's nothing there, right? And they're specifically written into the code. There is no ramification for not following the plan. So, if you're guiding somebody, if I were representing a person with a mental illness, I would tell them it's kind of a dog and pony show, right? You're trying to put together this thing. If you really don't want to follow it, why would you follow it? Just some issues that I personally have. I'm not saying this is legal or whatsoever, but just this is the proposed plan. This is something that the legislature came up with. I think it's a good attempt. Will it practically work? I don't know. There is a huge gap for mental illnesses that is not covered by anything. That's really the battle between civil liberties, and then the battle on the other side, caring for somebody who needs the help, right? And California tends to err on the side of protecting civil liberties. So, that's just kind of where we are. Yeah, Sarah.
Do you know if there's any limits, like who can file the petition? Does it have to be a family member or a law agency, or?
There are limitations, but I don't recall what they are. They are in the statute. Any other questions? All right, and then this is kind of an aside, but within a limited conservatorship, LPS conservatorship, and a probate conservatorship, there are 2 paths, essentially. There's of the person and there's of the estate. Of the person is going to be taking care of the physical person. So their health, food, clothing, shelter, kind of your basic activities of daily living. On the estate side, you're dealing with money. So how do they manage their money? How are you going to pay for rent? Things like that. These 2 can be separated in terms of who's controlling each, or it's possible to have only one and not the other. Yeah, I think that's all I want to briefly mention about that. It's just that there are differences there. Any questions on that portion? All right, so I'm going to get into a little bit more of the nuts and bolts, and I'm going to jump back and forth between my slides and then your exhibits. The exhibits contain most of the documents that you'll need to initiate a conservatorship. I will say in general, if you have never done a conservatorship before, I would be very careful starting one, largely because you're playing with somebody's life. With the trust administration, you're ultimately dealing with money, right? If you screw up, it's a money consequence. If you're dealing with conservatorship and you screw up, you could very well end up killing somebody. Maybe not directly, but not getting them the right care or things like that. I think it's a much larger consequence. So, I would just advise caution if you're getting into this to start off with. All right, so I'm starting from the perspective of we have already met with our client, right? I kind of did this last week. We started from the perspective of we met with our client, walked through the intake and things like that. This time I'm starting from the perspective of we've already met with our client. We found out what our situation is. I'm going to jump back and forth, honestly, on my assumption between a limited and a probate conservatorship because the forms are largely the same. So I'll kind of talk through each as we go. But just assume here, no objections. Generally, people getting along. There's not going to be any fights and things like that. That's a large assumption, but I will go with that for now. So the couple documents that you need to begin off with, I'm just going to list them, then I'm going to walk through them. There's a petition for conservatorship, which is what it sounds like. It's the underlying petition and the underlying document behind everything. There is the ability to get a temporary conservatorship. It's exactly what it sounds like. It's temporary, it's for a short period. It can usually be brought on a semi-ex parte basis. I mean semi because you are required to give at least 5 days notice. So what will usually happen is you have to serve the person, and then 5 days later, you either have your hearing or the court will accept the submission of the paperwork, depending on which county you're in. Conservatorships, just as a brief, is very county specific in terms of the direction that a case will go and in terms of the procedure. For example, in Alameda County, if you do a petition for temporary conservatorship, they're going to set it for hearing usually on a Tuesday, like a week out from when you file. Alameda County, it's going to be a Thursday, approximately a week out. Contra Costa County, they decide we don't usually have hearings on these things. They consider it on the papers, right? So you submit it, and most temporary conservatorships that at least our firm files get granted because there's nobody to argue the other side, right? That is usually designed to last until the general conservatorship can be heard, right? So you cannot file just the temporary without also filing a general. There's a capacity declaration. This is a form from the doctor. I say the doctor, it's form from a doctor that usually has seen the proposed conservatee, and it's designed to give a medical opinion on whether this person has capacity or not. So our clients usually can't get it or can't complete this themselves. They have to bring it to usually the treating physician, but if they're seeing a neuropsychologist already, that's a good person, or they can set up an examination and things like that. These can be very difficult to get, particularly if the conservatee is a Kaiser member. Kaiser is very protective of their records, and rightfully so to some extent. So they often will not provide the capacity declaration back to the petitioner, the family member, whoever that is. If you think about that from a medical perspective, it actually makes sense, right? Because they don't have the right to somebody else's medical records, at least not yet. From a practical perspective, sometimes it's very annoying and very frustrating to deal with. That being said, that is a requirement for a conservatorship to be granted, is that there is a capacity declaration from a doctor. It doesn't actually have to say that they have no capacity, but there has to be a capacity declaration. A bond. Yeah, sorry, question.
How often have project with the process of forcing the capacity declaration out? Sort of intermediate step between training that and the.
What Kaiser will tend to do is they will tend to submit it directly to the courts, and then you don't see it, right? But as a petitioner, you have the right to go to the records department and pull it. So I get it kind of after the fact, but you're going to get it after the fact anyway.
But what about when they're just dragging up?
I have only had to enforce it ever once, I believe. Ultimately, we've been able to work well enough with them to get it. Something though, from a more practice perspective, our firm doesn't really take on conservatorships that we think are questionable, right? If we think somebody's on the borderline and they may be able to make their own decisions, we're not going to file that case because that's not really the type of people we are. We're looking to help the people who really need the help. So our fights on capacity declarations are usually when the person, the conservatee, won't go to the doctor, right? That is more of our fight as opposed to getting it from the doctor. If they won't go to the doctor, there is an ability to essentially force it, right? You go through the evidence code, you can force them to undertake an examination beyond the scope of today, but that ability is there. It's fairly rare that we have to go down that step. Largely because if you're coming from the attorney representing the conservatee perspective, my best advice to them, if I'm representing them, is yeah, if you think you have capacity, undertake the examination and show them the proof. Right? If you think you know what you're doing, the examination will show exactly what you say. So why not do it? Right? It's a fear of being declared incapacitated is what holds people back. Sorry for those of you online, I did not repeat the question. The question I'm trying to remember at this point is, what do you do with the capacity declaration if the Kaiser won't provide it? Essentially, I went into some science. Yeah. All right, so the bond. A bond is only necessary if you have a conservatorship of the estate. A bond is like an insurance policy. So the idea behind it is if a conservator is coming in controlling my assets, they need to provide insurance so the court can make sure that if I decide to take all the money and go on vacation to Hawaii, there's a recourse to recover that money, right? So the bond ensures that that money can get back. For somebody to do that, you have to file claims, you have to file, it's called a surcharge against the conservator. There's a whole process for that, but the idea is insurance. Weirdly enough, my first job was working for a charity company and we did court bonds. There is a company in the area by the name of Phillips Bonding. They're kind of everywhere. They do most of our Contra Costa County probate bonds. I knew their names before I ever met the people because I saw them from the insurance side. It was just kind of a fun aside. Some other documents that are needed. There's a screening form for the conservator. They have to declare under penalty of perjury a whole bunch of things. Essentially, they're a good person, right? That's the concept. They're not convicted of any crimes. They've never stolen money. They've never declared bankruptcy, things like that. The key for conservator screening is to be truthful. Not being truthful on that may very well get you disqualified, even if the underlying offense may not have. An idea behind this is if they were convicted of drunk driving when they were 20 years old and they're now 60, from a court perspective, that doesn't really affect their ability to control and to help somebody else. But if you're not truthful about it, that's a lot more problematic, right? There's a confidential supplemental information. The idea behind this form is maybe there's some things you don't want to make public, right? So a conservatorship is a public proceeding. The public has a right to see everything except for these confidential things. So for example, we have somebody who's being scammed who is very sensitive and thinks that they are so controlling everything. So potentially in our petition, we say something along the lines of this person is being defrauded, and that's it, right? We leave it like that. In our confidential supplemental to provide to the court, what we could provide extra information of, it's actually the daughter that they're living with that is scamming them, right? So we don't necessarily want the daughter to see that information and to come in. That's a way of presenting information to the court without public knowledge. There's a conservatorship training or conservator training that differs by the county. Although COVID has changed some of this as well. Contra Costa used to hold a workshop for conservators like once a month or so. That is now gone. There's a video that was originally produced, I believe, by Sacramento County called With Heart. The idea behind the video, I've only watched a portion of it. It's like 30 minutes. But the idea behind the video is you're caring for this person and you're doing it to care for them, not for whatever you want, right? That's the concept. You do have to go through that. Each county has different requirements. I believe all counties that I work in now require that you watch the video and provide some sort of a declaration. Actually, let's see. Yeah, so those are the initial documents. And yeah, question.
Yeah, so this is a general process, things that have to be filed. Is there a streamlined process, I guess, for someone that has a guardianship when they turn 18 to then change that into a conservatorship when it's due to some kind of incapacity?
So the underlying question is if somebody has a guardianship, so when they're under 18, is there a smooth process for transitioning this to adulthood when they turn 18? I kind of chuckle a bit because you think the government would be that efficient? The answer is no.
Okay.
The answer is no. You do have to go through the full process, the full protections and everything.
So do you normally like file for a temporary, like right before they turn 18 and then?
For a limited conservatorship, there is the ability to get it before somebody turns 18, then the order becomes effective at the age of 18.
Okay.
We do see a good number of those cases. So, yeah. Those are usually from clients that are plugged into the regional center, plugged into networks of parents
Yeah.
who have gone through this. Any other questions before I jump into the forms? All right, so I'm gonna hop off of my PowerPoint and go over to the petitions. All right, and just know that this is very practically difficult for me to look at both you and the screen, so it's gonna go back and forth a little bit. So this is your initial petition. It's, I believe, 7 pages long, if I remember correctly. 8 pages, close. And I'm going to go over some of it in brief, some of it in detail. All right, so the very top is just your heading, that's your firm information, your information. The court information, that stuff like that is fairly basic. At the beginning, you have here, so I find my mouse. Tell me if you see it, because I'm trying to find it. Oh, I see it. All right, so over here, you have your boxes for what type of conservatorship are you filing. Right, so by default, you'll see this is on the same form for a limited and a general conservatorship. So of the person of the estate, I mentioned those can be separate, those can be checked off or not checked off. And then if you're doing a limited conservatorship, that box would be checked off. The first box, petitioner. Who is that? That's the person filing the case. Does it have to be the same as the proposed conservator? No, it doesn't. I, as a family member, can file to appoint a professional fiduciary to serve as a conservator instead. So those could be different people. I really wish I had a laser pointer, but I don't. So petitioner, that's you. Name, address, phone number, right? So that becomes public. Be appointed as so petitioner, you're requesting that the next line is name. That's who you want to appoint. So those could be different people. There's the first section is dealing with of the person. B there, you're dealing with of the estate. Under C, you're talking about bond, what is required, what is not. You can argue that bond should not be required. That's generally not going to be granted by the courts unless you are a corporate fiduciary. By corporate, meaning you're coming in, Bank of America, we are a trust department coming in. It is not for a professional fiduciary. They do not count as a corporation. So then that would be your bond amount. The bond amount will usually be the amount of liquid assets of the conservatee. Real estate is excluded from that because the conservator does not have the petitioner. It may not be. But you're giving some background. Who is this person? Were they nominated by anybody? Are they the spouse? Are they a relative? Are they something else? Are they a professional fiduciary? If they're a professional fiduciary, you have to give explanations on kind of how they got engaged. The idea behind this is the court's looking for conflicts of interest, right? Were you engaged prior? Are you representing somebody else? Like things like that. That's what the court is looking for there. You then have to declare what is part of the estate. This is only necessary if it's a conservatorship of the estate. You're giving estimates on what the value of the assets that you're dealing with. Right. So you'll see things they'll talk about income as well. Do you have to have this information ahead of time? No, it's helpful, but you don't have to have it. There is
Hey, Alex.
you are appointed as conservator or your client is after the fact, and you find out your bond amount is insufficient. Both the attorney and the conservator actually have a personal duty to file for an increase of bond if they find out that's insufficient. So it's something that's interesting here.
Hey, Alex.
Due diligence, this section at the top of the page there, that is talking about you have to show the court that you've made good effort to find all the people that are required to get notice. For notice purposes, the people who are entitled to notice of a conservatorship proceeding, relatives of the second degree. Right, so from the conservatee's perspective, you're looking at their children, grandchildren, so that's going down 2 lines. Go up 2 lines, so parent, grandparents, and then siblings. From there, you go parents, then down 1 to a sibling, right? That's your relationship level. It doesn't mean you have to have found them, but you have to have shown that you make a good effort to find them. For the court purposes, that usually means you've done online searches, you've asked people who may know where they are. Some counties require you to do land record searches and stuff like that. That is somewhat county specific on those requirements. The second part of that is you have to give a statement regarding the preferences of the conservatee, meaning you have to have asked them, who would you prefer to serve as your conservator? And you have to report their response. If they don't give you a response, what we do often is, they were not able to respond, but they've always lived with their mom or something like that, right? You give some sort of indication that this is the right person. Under 5 here, this is where you get into your argument as an attorney. This is where you're making your legal argument, right? Why is a conservatorship necessary? So part C1, you're showing of the person. C2, you're showing of the estate. Again, we talked about confidentials and being able to file things there. These are just places to put your arguments. 10 here, if you file a temporary conservatorship, this is where you would indicate that you have done that. And then under 11, we're listing the relatives. These are the people entitled to notice. You'll notice that they don't have relatives. You actually have to go through searches to find out who the next of kin is. That's very hard because when you don't have family members, there's nobody to talk to. But there is the ability to do air searches and things like that. We've done that before. And that is your basic petition. Did I put the attachment? Yeah, I did.
Question.
Yeah.
That I should probably let it go. On the this form, if the proposed conservatee has a deceased spouse, are you required to note that there, like you are on probate petitions, or no?
Technically, I think the answer is no, but that is county specific, right? Some counties will look for it, some will not. If they're deceased, I don't believe you have to put it in, so I don't know that for sure.
Okay.
This is an attachment to that petition, and this is specific for a dementia case, or under the new terminology of law, a major neurocognitive disorder. I have not seen this referred to anything other than dementia, but dementia kind of became a bad word. So that's why this is in there. So if the person had a stroke, this is not required, right? If they had, I don't know, heart attack, whatever else, right? This form is not required. This is specific to a couple of different things. With dementia, there is the ability to force them to be in, quote, a secured perimeter residential care facility. If you read the statute of what that actually means, there's almost no facilities in California that require it. It essentially means there's gates and stuff like that everywhere. What a lot of courts take this to mean is a memory care unit in an assisted living facility, because they have a physical locked door where you can't get out. Whether it practically is true or not, I don't know, but it's safe to assume that if they're in a memory care facility, that this is what you potentially need the authority for, is to put them in a locked facility. Contra Costa for a long time had a assumption that this facility type did not exist, so you never had to apply for this. That assumption has changed with the changing of the judges. The second thing there is the ability to authorize medication appropriate for dementia care. So otherwise, you do not by default have that authorization, so you do need that authorization if they have dementia. This is fairly common for this to be granted. It's not usually an issue, but it is specifically needed as a power. Yeah, the second half of this is just essentially saying the same things, right? Medication, restricted placement, that these are necessary. And then that incapacity declaration, that's with 3. It says a medical declaration executed by a doctor, blah, blah, blah. That's what the capacity declaration would be. You're essentially indicating, yes, we filed it or we are filing it.
Alex?
Yeah.
Power went out at petition 1C, not to review now, but at the end of your entire presentation, can you review it? So we both capture it in recording as well as the folks online that missed it at the end.
I will tell you, there's absolutely no way I'm going to remember that in about 30 minutes. So please remind me in about 30 minutes.
I will
Yeah.
do so, but I wanted to get it on the recording. So as people watch it later,
Perfect.
they know it'll come at the end.
Perfect.
Thank you.
All right, exhibit 3, this is an example of a capacity declaration. You don't generally fill this out except for the top section, fill out your captions. And then this first form is really it's really just this top little section here for you to complete, right? So we're looking to see what are you requesting the doctor complete. It's usually if they have the ability to attend the court hearing. And then secondly, if they have capacity to give consent, to give medical consent. Then thirdly, if they have a major neurocognitive disorder, right? So those are the 3 things you're requesting the doctor complete. Do doctors ever read that section? No, they don't. They just want to get this done with and get it out. The rest of this is all for them. Just a couple of basic practice pointers. Doctors like to complete a portion of the form and not read through everything. They will often leave out their office address. That is generally required. So you may have to go back to them and request that. The bottom, they don't like to date it because it's in kind of an odd spot. If you notice it, right here. So they print their name here, they sign there, and they date here instead of on the side, which is unusual for a form. So doctors will miss that. The court does like to see things dated. Some judges are more flexible than others, but that is something we've had to go back to a doc for. I'm not going to go over this one in detail because you don't really have too much control over it. When I'm getting it back and reviewing it, you'll see all these things. It gives the ability to mark what their moods are, whether it's appropriate, things like that. The main key of what I'm looking for is this bottom box. Ability to consent to medical treatment. Which box is the doctor checking? They check lacks capacity. You're usually fairly good to go. The top one has the capacity to give informed consent. I would likely tell my client, you're probably going to lose this case if you try to move forward. Like before, there is a special attachment here for a major neurocognitive disorder. And it talks about the same things: placement in a locked and a secured perimeter facility or medication. Any questions on that? All right. The next one then is, this is the confidential screening form. This is going to be mostly your client's information. Or in the case of the professional fiduciary in our audience, it would be your information. So you're looking for what type of conservatorship this is at the top, filling in name, date, social security number, driver's license number. You're seeing the court is actually getting a good amount of information. They do run background checks, right? So they run an actual check to see, number one, if you've declared everything that you're supposed to, right? So if there's a discrepancy and an old conviction comes up, that will be something that needs to be addressed. And we've had to deal with that, things like that. But basically just to see if you're complete, right? That's the concept. If you're related, it goes through that, whether you're nominated or not. This is nomination by the proposed conservatee, right? So if that person in their estate plan has a document on their power of attorney that says, I nominate X, Y, and Z to be my conservators, you can check that box, right? When you provide that document. That does provide a credibility to your argument of, yeah, this is the person they wanted me to be in charge. So whether you're a spouse or not, that does make a difference. And they specifically ask whether you filed for dissolution of a marriage or separation, because it affects rights and whether there's a conflict of interest. right? So I am working on a case right now where a spouse has filed for conservatorship, and they're making the argument that all the assets, despite being held in both their names, are their own separate property. There's a conflict of interest there, right? Should they really be in that position of the conservator? Probably not. My most recent move in the court case has been to recommend to remove them as a conservator, right? So things like that. Registered domestic partner, they have generally the same rights as a spouse. That's why that's there. Whether they owe money to the proposed conservatee, again, looking for conflicts of interest. And then whether they're an agent for a creditor of the proposed conservatee. Like a probate, technically a creditor can file for conservatorship, usually of the estate. I've never seen it happen, but it can happen. Again, you're looking for conflicts. I seem to have missed the page there, but there is a second page of this form. I don't know if it's in your packet. Is it? Yeah. Okay. So in your packet, you'll see the second page there. Actually, I think what happened was this is front back, and I think when it got scanned, it got missed. But there's a series of questions regarding declarations you have to make. Either you have or you have not done certain things. Right. So you'll see things here like bankruptcy, being convicted of a felony. There is a box for it if you're a professional fiduciary. That box would have to be marked yes. And whether you've ever been removed or resigned from a trust or from a conservatorship. For a lot of our professional fiduciary clients, they have, right? They've resigned at some point or another. So that's a declaration we make there. Any questions regarding that? All right, then the next form is the confidential supplemental information. And this is the extra information to the court that I mentioned, right? So again, you're providing personal information of the conservatee at this point, their date of birth, social security number, and their age. And then there's a whole series of abilities to give arguments here, right? So their ability to provide properly for their personal needs. You can give examples and things like that. This form, if you'll notice at the bottom, is a January 2024 form. It's a brand new version of this form. It used to be just a blank kind of block that you fill in. There's now specifics that you have to fill in. You have to go through an argument of why alternatives to a conservatorship don't work. All right, so the supported decision-making that I mentioned there above is there. The argument can very well be they have no ability to understand anything that they're being said, or they're nonverbal, right? They can't express their opinions. Who they would define as a health care surrogate, essentially, if they have an advanced healthcare directive. The court's looking through this person's background to see, is there anything that gives indications of who they would want to be in control? And if there are, those people have priority generally. Other alternatives, is there a trust in place? Why won't it work? Is there a power of attorney in place? Why will that not work? A conservatorship is a last resort, right? That's the whole concept, is unless you absolutely need a conservatorship, let's go some other path. And I think on the scan, it got missed as well. So the last page of this is health or social services provided. Essentially, what care have they received or are going to receive? And then where is this knowledge coming from? Is it from yourself? Is it coming from somebody else? Things like that. Any questions on that? All right, and then the last one, I think, for this section is the verification of viewing the conservatorship video. They handily give you the link to the video there. It is on YouTube, like everything else. You watch the video, you let the court know that you've watched the video. I've never seen this done, but I think the court investigator is supposed to offer you the ability to watch it at their office. For a practical perspective, I've never seen it happen. I can't even find the court investigator's office for the most part. But that's just a brief mention of that. A citation, I will get into this. I'm going to hop back to my PowerPoint, and I'm running at about 30 minutes, so I have some time. And this next slide is going to, is going to hop back into, we've now started with all, I'll get to you in 1 second, that we've now had all of our documents, we've filed them, right? So we've started the process of a conservatorship, you've gotten the court hearing date, things like that, and what do you do with that? That's what I'm getting into. And let's get the question now.
Oh, about that last one, the verification of feeling, There's not a form in consequence county, is there?
There's not. We put it on pleading paper is what we do. If you ultimately filed that form, I don't think the court would argue with it. Although I don't, that form we got from Solano County, I don't know. I didn't look if it was specifically for Solano. It looks like it is, right? The heading is for Solano. Yeah. All right, so we have now filed. We now have a court hearing date. Usually your court hearing date after you file is going to be 60 to 90 days out at minimum. And it's that way for a reason, because there's a whole lot of process that happens in this time period. This is mainly for protection of civil liberties. And I'll talk a little bit on the next slide, I believe, about the Brittany case and how that changed a lot of things. Sorry, I'm on the wrong slide. Here we go. So built-in protections. Number one, notice, right? We talked about notice and who is required to get it. Second degree relatives for limited conservatorship. The regional center is required to get notice as well. If they're on Medi-Cal or if they're a vet and things like that, there are other notice requirements for those. Essentially, you have to notice the VA department. If you have Indian ancestry, that's a big one. So that's Native American ancestry. You do have to give notice to the tribe, and there's a lot of details that go into that. The concept behind that is the tribe has jurisdiction unless they give it up, right? So if the tribe wants to control it, they can. I have not seen a tribe step in. I filed guardianships with Indian ancestry, but not conservatorships. So just so you know that those are out there, so be aware of that. So that's the first protection. People get notice and are required to get notice. You do have the ability to request the court waive notice for good cause. Good cause would be something like there's a restraining order against this person, and they've already been convicted of elder abuse. Right, that'd be a good reason. They're going to come in and physically harm the conservatee. That would be a good reason. It's court's discretion on whether they want to waive that notice or not. So that's the ability is there. Citation. This is notice to your conservatee or proposed conservatee. A citation is a form I'll go over in just a second. It basically tells them that your civil rights are at liberty, right? Your civil rights are at jeopardy, and that somebody is filing to take them away. That's what the document essentially says. They're required to get personal service. Right? So personal service means they have to get handed this document by a process server or by somebody not related to the case, right? The same is true of a temporary conservatorship. I mentioned the 5 days notice for that. Personal service is required for that as well. The idea is this is so protective and it's so restrictive of the person who's losing their rights that they have to know what they're dealing with. From a practical perspective, people with dementia, if they're kind of far along that path, you're going to get somebody who may be nonverbal, who's just getting handed this piece of paper. It's usually fairly non-confrontational, but we have had ones where it is confrontational. For a practice pointer, our firm does use process servers for this. We don't do it ourselves because it's too dangerous. The court investigator, I've briefly mentioned them across kind of the time frame of this. They are a branch of the court. Their role is to do exactly what their title says. They investigate the situation. They provide a report to the court on what their findings are, the details of their conversations with the parties that are involved. Usually they'll talk to the proposed conservatee at minimum. They'll talk to the proposed conservator at minimum. And then sometimes surrounding family members they'll talk to. The idea is for them to provide a neutral report to the court. Some courts require that the investigator give an opinion as well on whether the conservatorship is warranted or not. Other courts do not, and they're simply providing information to the court. They're generally people who are, we've had turnover in the Contra Costa office, but they're generally people who are fairly familiar with the process and who know what they're doing. The regional center, I've already mentioned them before. For a limited conservatorship, they are required to give notice, to get notice, and then to provide their own report. The proposed conservatee generally gets appointed an attorney of their own. The process, I say generally because there are cases where it's not required by law. So the stroke example, for if they're incapacitated in the hospital in a coma, had a stroke, they're not required to get an attorney. From a practice perspective, I like to have an attorney representing them. Just so there's somebody to speak on their behalf. It feels kind of weird to have them not represented at all. For dementia, for limited conservatorships, an appointment of an attorney is required by law, so that you'll always see an attorney there. The process for this differs by every county. Alameda County, there's a, for probate conservatorships, there's a group called Legal Assistance for Seniors. They're a nonprofit organization. They represent the proposed conservatee. So they will just get appointed always, almost always by the court. Contra Costa County, there's a panel of attorneys. I am on that panel. Tracy is on that panel. It's usually attorneys who are experienced in this area of law. Solano County, the public defender is always appointed, right? So very different depending on the county you're in. The Free Britney movement. Just briefly, it was in the news a lot, so I just want to bring this up. Prior to the Britney case, the law did not require, what the law said was the role of a court-appointed counsel for the conservatee is all of this, right? To be a zealous independent advocate representing the wishes of their client and to present the best interest of the conservatee to the court. Best interest can be very different from advocating for what your client wants, right? I can have a client who is being scammed every day, tells me they can control everything they want to control their own assets. I have a duty to advocate for that. Pre-Britney, I also have the ability to tell the court, well, I don't know if they really have that ability. You know, they've shown that they've been scammed. I think it's in their best interest to have a conservatorship. There's different ways of viewing this, but post-Britney, that best interest or the best interest of the conservatee, that's gone. The only duty of a court-appointed counsel is to be a zealous, independent advocate. My client tells me they want to control their own assets, that's what I argue for. If they think they want their dog living with them and they want to live in filth, that's what I advocate for. For me as an attorney, that creates a bit of an ethical dilemma if I see that they need the help, if I'm representing them. But I can be disbarred, right, for arguing the other side, because that is going against my duties, ethical duties as an attorney. I have not had to deal with that situation yet, so I can't tell you how I would actually handle it. I know that it will be very difficult for me and it will be up sometime or another. Right, so if my client wants to push for a trial, they have the right to a trial, and I would have to do that. Multiple questions. Adelia?
How was it that that was what was decided?
What happened with the Britney case, one of her underlying complaints was my court-appointed counsel didn't argue for what I wanted. They ignored me, they didn't present it to the courts. I happen to have, it's a secondary connection to the court-appointed attorney. He's a fairly good attorney. I'd be surprised if that's what truly happened. Again, I don't have specific insight, but what she presented was, you know, I never wanted this, I blah, 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 and he never argued for me. So the legislature took a look at this and everybody from a social perspective, right, people didn't like that. There's a lot of pushback against that, the whole Free Britney movement. So how does, you know, any legislature get done? Oh, people are complaining about it. Let's get ourselves in the news. Let's put something before and pass a law, right? So the legislature in California passed a law that changed this section. Yeah. Sorry. The question was, I'm getting worse at this. The question that I just answered was, how did the Britney Spears case affect this, affect the court-appointed counsel? And sorry, next question.
Is the requirement of notice, is that calendar days or court days?
I don't think I put any days up there, but it is calendar days. So if by default for notice for second-degree relatives, it's 15 days. That is calendar days.
And then that's the actual notice form and a copy of just the petition, or
There's a notice of hearing for a conservatorship. Yeah, that's the form you would use. That's
you have to mail
I don't recall the exact answer to that. I think for a practice perspective, it's a good thing to do. I don't recall if there's a box you have to check off.
Repeat the questions. Sorry.
The question was, I need to remember these things as I go. The question was, how do you give notice? What's essentially how do you give notice? And it's on, there's a judicial counsel form for notice of hearing. Then the second question to that was, do you have to provide a copy of the petition for conservatorship? The answer is, I'm not sure, but as a practical perspective, it's probably good to do so. Yeah.
probate referee. How do they fit in terms of the court investigator and
Because of time, I'm gonna cut that off. The question is regarding probate referees and how they get involved. I'm not gonna answer that now, but if I have time, I will get into that towards the end. Any other questions for now? All right, So, sorry, and the solution at this point regarding the best interest and what actually makes sense for a conservatee. Since the council can no longer do it, what's happening in a lot of cases is there's a request for a guardian ad litem. A guardian ad litem is presumably a neutral party. It can be an attorney, it doesn't have to be an attorney, who comes in and who presents to the court what is in the best interest of the conservatee instead. So that can be very different. I am currently the guardian ad litem on a couple of different cases. I thoroughly enjoy the role because I get to present what I think, not what my client thinks, right? It's sometimes not fun to present what you think is wrong to the court. That being said, there's problems with the system because the guardian ad litem adds costs, right? You're paying another attorney to get involved. At the end of the day, you have, your petitioner's attorney, you have your guardian ad litem, you have your conservator's attorney. So at least 3 attorneys are involved in most cases at this point. Yeah, Dolly?
So a CAC can't be appointed to Danielle, or can they be appointed to?
The question is, can a court-appointed counsel also be appointed as a guardian ad litem? Not in the same case. Yeah, because you have differing roles. All right, so I briefly talked about some of this already, but what happens then after you complete those documents? I'll jump back to those documents, I think, in a second. So hearing dates, I mentioned 60, 90 days out, right? Because all of this process, people need to talk to each other, people need to interview and things like that. They get given that time period to do so. That's why you have a 60 to 90-day period. Objection. The conservatee can object. Other people who get notice can object to the conservatorship. So are you dealing with these things? Are you potentially going to trial? Right? These are all considerations that will come up. Do you need to do discovery? Are you going to, by trial, I really mean an evidentiary hearing. Do you have to present witnesses? Do you have to do any of that? That will all come up after you file. The standard of proof for a conservatorship is clear and convincing evidence. For those of you who are fresh off of law school, you probably remember this better than I do. That means that it has to be, it's not quite to beyond reasonable doubt, but it's close, right? Preponderance of evidence is more likely than not. So that's 50 plus anything %. This is probably, if you had to guess percentages, probably in like the 75 to 80% range. You have to be fairly confident that this is the case, that this person needs a conservatorship. And I'm going to briefly mention the last forms, and then I will go over the forms. So post-appointment. So conservatorship is granted. Your client is now the conservator. There's now a conservatee. There's a couple of different documents that you need. An order is what the court signs and actually appoints somebody. Similarly to a probate, there's something called letters of conservatorship. Why it's called letters, I've never quite figured out, but it's literally a piece of paper that gives the conservator authority. Did you have a question? Okay. And it details out kind of what the powers of the conservator are. You present that to the bank to control assets and things like that. Notice of rights. So even after a conservatorship is granted, the conservatee maintains some rights, right? So the right to get married, those things that we mentioned. They get a document that gets mailed to them that provides them notice of what their rights are. The conservator has to put together something called a general plan. This is usually of the person's side. So what is the plan for their medical care? The court wants to see that the conservator is thinking about these things and planning ahead. So that is required. Inventory and appraisal, again, similar to a probate, you do have to provide to the court. What are the assets that we're dealing with for the conservatorship? To answer the question regarding a probate referee, this is when the probate referee gets involved. Same as a probate, you have to provide your non-cash assets to the probate referee for them to put a valuation on it. The idea is you are not a neutral party, so the probate referee is. Cash is easy. It's just a number. It's exactly what it is. So you can value that for yourself. There can be details and complications on that based off of what the asset is. On a case I'm working on, we're trying to put a valuation on a business, right? So we have to get a business appraisal and do a whole bunch of other stuff to actually get a valuation. Move notices, I just want to briefly mention. So I mentioned earlier that if within the conservatorship, you can move a client or the conservatee within California without court permission. You do have to tell the court that you are moving them. That's not permission, right? It's a notice that this person is now moved. There's both a pre-move and a post-move notice. Technically, the pre-move notice has to be filed more than 15 days prior to the move. Does it practically always happen? Not really. Sometimes your client will tell you, hey, we've already moved them, and then you file just the post move. The post move is exactly what it sounds like. They are now established here. This is their new address. And I have examples of those forms. I have 15 minutes. I'm going to jump over to the forms. I think I can get through them. So I don't think, did I mention the citation already and go through it? I don't think so. So the citation, briefly, this is what the conservatee gets. I think it's a little bit silly as a form in the sense of it's not easy to read, right? It's not easy to process. And for people with limited or diminished capacity, this is going to be difficult to understand. How I would, if I put together this form, how it would look, big print, right? Big print, very easy words to understand, and let them at least get some semblance of being able to understand what they're reading. However, this is what we're working with. So they do get a copy of this. You'll see all the boxes that need to be checked off. Those are essentially the type of conservatorship that you're applying for. And it tells them, yeah, you can be disqualified from voting. You may lose your rights and things like that. Right? So that's all in there. There's not too much for you as a attorney to fill out for your client. The second page is a proof of service. So the person who's serving it does have to fill this out, usually the process server, although it doesn't have to be a process server. Yeah, question.
I noticed that the scan is not, didn't pick up on the double side, just so that there's the second page of the clerk seal.
Oh, okay. Yeah, on the citation, you do have to get, that actually is fairly significant. A citation has to get issued. What that means is you have to file it with the court, the clerk stamps it, and that's called, it's been issued. Court-appointed counsel has the right to waive citation to their client. They don't have to waive it. I sometimes will, sometimes won't, depending on the scenario. But it means, but it at minimum has to get issued. It's to me a little bit of a weird requirement, but that does have to be done, whether it gets practically served or not. This is just in here. We use this on occasion. It's really to speed up the court process of appointing an attorney for the conservatee. We file this with our initial petition to get the process started. The court will do it on their own motion, but it usually will happen much later in the process. And sometimes it means you have to get a continuance because of it, things like that. We like to get things done in one hearing. Yeah.
All the different counsel starting on line. I mean, it sounds very expensive. Have that many attorneys involved. Does that all come out of the conservative state?
The question is, how do all the attorneys who are involved get paid? Generally, most of the attorneys involved have the right to get paid from the conservatee's assets. So yes, that is a large problem with conservatorships. Through our county in Contra Costa, if we get appointed as guardian ad litem, we have the ability to demand the county pay us directly. So far they have. I don't know if that's ever going to stop, but so far they have. But otherwise, we can be appointed through a company called Independent Counsel as well. They do criminal conflicts checks and things like that. But there is payment, but it's at a much lower rate. So the conservatee has no assets. They still need counsel.
Yeah.
So we have many of these cases where we get appointed, and I think the rate's like $100 an hour or something like that. It's not nothing, but it's not close to probably the right compensation.
Okay.
This is an order. So this is presumably what the judge would sign. Again, you see a lot of check boxes. If you're filling this out, read carefully. It's very easy to miss boxes. So who the judge is, when the hearing date was, whether the person who is cited, who is the proposed conservatee, whether they appeared. Then the court finds a whole bunch of stuff, right? All notices required by law have been given. This is the least restrictive measure of, the conservatorship is the least restrictive means of being able to provide support. Most of these things are fairly basic. I'm not going to go through them, but my main practice pointer is read each line every time and read it carefully. Because even for me going through it, it's very easy to miss a box and you have to get a continuance for it. And that's very frustrating. Yeah, and you'll see things like number 22 here, the conservatee is disqualified from voting. Taking away somebody's rights can be as simple as that. Check off a box, the judge signs it. Right. There's portions in here again regarding dementia care, so 26 is specific there. There's boxes specific for limited conservatorships and the rights that are being taken away there. So those are things to look out for. You'll see 31, they do their best to indicate it for you, right? 31, 32, 33. They specify the limited conservatorship powers. Again, the letters of conservatorship is the piece of paper the conservator would bring to the banks, or that actually gives them authority. It does have to be a certified copy that usually gets taken to the banks. Certified just means you bring it to the court clerk and you ask for a certified copy. You pay, what's it, $50, something like that. They stamp it and it's now a certified original or certified copy, whatever you want to call it. Again, those same boxes are all there. Right? It's what authority do they have is what you're detailing to the people that you're handing this form to, right? So they can read it. Then most of them don't read it. Banks in particular do not read these forms. You've probably sensed over the past 2 weeks that I have a lot of antagonism towards banks. I have not found a bank that does what they're supposed to do. Notice the conservatee's rights. Again, you know, this one is a little bit better. It breaks down some details of what they can still do. But this is presented to somebody who's already been conserved, right? So keep that in mind. It's pretty much a court form and with a proof of mailing. I believe there's one other page I believe that got skipped on the scan, but essentially it's a detailing of rights. Yeah, there's a second page to that as well. For those of you following online, I believe you have it in your handout. It's simply just I don't have it on the screen. Determination of care. Again, this is on the medical side. So we're talking about what level of care do they need. You'll see here, this is the information, kind of where they are, where they're living. The second page, which is not here, talks about kind of what level of care do they need, right? Do they need to be in a house? Do they need to be in a care facility? How many hours of care a day do they need? What activities of daily living do they need assistance with? Things like that. Whether they're living in their own house, kind of what care do they need brought in? The idea is the court's looking at, you know, is the conservator really digging into this, and they want them to. You know, I find this form to be very good. You know, it forces your client to put things on paper. I'm actually going to stop looking at that because it's easier to just look at my form here, and you guys aren't looking at it anyway. Inventory and appraisal. This is very similar. If you'll notice, it's the exact same form as a probate. Again, the idea is you're detailing the assets of the conservatee, except on this one, you're checking off the box that says conservatee instead of the decedent. The same process for assets that are cash. You can submit it on attachment 1. I have an attachment there. You would just write in 1 or type in 1 and list all the cash assets. Anything not cash does go on attachment 2, which you send into the probate referee. You pay a small percentage fee to them for their job, and then they provide you a report back on what the valuations are. If you get it back, you'll see on the front, there is a section about bond and whether bond is sufficient or not. If bond is not sufficient, remember, I mentioned this before, you do have a duty to petition to increase bond. That pretty much every county I know will take that petition by ex parte, meaning without a hearing, and then you just present it, the court will order it, and then you get order to increase bond. You work with your bond company to actually get the physical bond filed. With a conservatorship, though, there is an extra form called a notice of filing inventory and appraisal. The idea behind this is the relatives have some interest in knowing what this person has, so you have to let them know you filed the inventory and appraisal. The last forms I have here are the pre-move and post-move notices. And these are fairly basic in terms of what you're reporting. I just mainly wanted you to be aware of what these look like. You're telling the court and other interested parties that you are moving somebody, you know, within the state. You're moving them out of the state. Again, you need court permission, so you need to petition for that. Does that practically always happen? Not really. We have a case right now we're working on where the conservatee got moved to China without anybody knowing, and is still in China. So, you know, does it happen? Yeah, it happens, and you have to deal with that. that's all I have on the forms, and I have one last slide to go through once I can find my PowerPoint thing. It's really just what happens, right? What happens after this conservatorship is already in place. So after 1 year, if you have a conservatorship of the estate, you are required to file an accounting with the court. Similarly to a trust or a probate accounting, there's this format, it's the same format specified by the probate code, which details out all the transactions. Again, you're an open book, you present all the bank statements, that's essentially what it is. The court investigator should follow up annually. Doesn't always happen, but it generally does. And if they see anything of concern, they may request that the court set a hearing, right? So in that case, you may need to appear to report what's going on. If you're filing an accounting petition, the court will hear anyway what's going on, because in your report, you tell them, how things are going, whether there's any problems, whether there's any issues with the finances, that all gets reported to the court. A conservatorship by law terminates with a death, or otherwise by court order. Right, so there is the ability to lose capacity and regain it. Right, think of your stroke example. Somebody is in a coma in the hospital. They come out of the coma. They rehab. They have potentially regained capacity. So conservatorship can go away with that. I believe that is all I have. And what questions do you guys have? Yeah.
When an estate planning bundle of documents nominates a person to be conservator, how does that change this document?
So the question is, if you have a nomination within an estate plan of a conservator, how does that change the conservatorship process? It doesn't really. All the documents still have to be done. But I pointed out there are some boxes to check off. Am I a nominated person? Right? If you are a nominated person, you provide that document. It proves a lot of weight to the court. Otherwise, by default, the order or priority is kind of the same as a probate, right? It's family members first, then there's a whole level of priority. But a nomination by the conservator themselves, the court will say, yeah, when they were for sure of sound mind, they made this decision, then yeah, it makes sense to appoint that person, unless it can be proven that they have stolen money or something else is inappropriate. It's an opinion, right? And it's a strong opinion. Any other questions? Yeah.
When a conservatee passes away, the next steps are just to file a notice of death and a petition for termination. Is there?
The question is, what is the process after a conservatee passes away? So yes, Irving mentions there is a document called a notice of death. You do have to let the court know that the conservatee has passed away. And secondly, if you have a conservatorship of the estate, you do have to do at least the final accounting. There's no money and there's just conservatorship of the person, you're essentially done. The court investigator may still follow up, but yeah, there's no actual hearings or anything like that set. Any other questions? All right, thank you very much. It's good to know my time is fairly good.
For the folks on Zoom and for the recording, can you go over the petition from 1C?
Yes.
Please and thank you.
So this is repeating the section on going over the petition starting from 1C. I'm not going to pull it up because there's no point.
Yep.
So 1C is talking about the bond, and the bond is a bond is the insurance policy again. So there may be reasons why a bond could be lowered or could be increased, or sorry, could be lowered or not required. That's usually real estate does not need to be bonded for, or if assets are in blocked accounts, that would get blocked out. I would ask that the people in the audience still stay quiet or go to the hallway to talk because they are still recording at this point. So that's a section on bond. There's a section under there regarding specific orders that can be given. Those are dealing with dementia powers or dealing with limited conservatorships. So you can get special powers and things like that. Going to the top of the next page, you'll see things on the limited conservatorship. You go through a section starting on 3 with what are the facts of the case. So where did this person reside? Who the petitioner is. Most of these things are giving background to the court, right? So on the facts, you're saying, is this county the appropriate place? For the petitioner background, how are they related? Are they not related? It's giving some of that background. 3C at the top of the next page is information on the conservator. Again, this could be the same person, it could be a different person, but if it's the same information. If it's different, you provide this new person's information. They're a professional fiduciary, there's other boxes and things like that to check off as well. And then it goes into what are the assets of the estate that you're dealing with. So what's the amount of money, kind of what is there? And these are usually estimates, they don't have to be exact, but it does help to determine the bond amount. That's what that's for. At the bottom of that page, there's a section on due diligence and whether you've made an effort to find the relatives to give them notice. Again, you don't have to give, you don't have to actually have found them. You have to show that you've done your best to find them. This usually means asking relatives. It means doing record searches or name searches online and things like that. Secondly, you have to ask the conservatee what they want, right? So you have to give a statement on what their preferences are. If they can't respond to you, you can simply present that to the court. On number 4, and some of this, if you guys haven't noticed, I did not go over because it's on the back pages. So I guess I missed that. But whether they are a patient on leave from a state institution, this is kind of other entities that would be entitled to get notice. So whether they're a member of they're a tribe member, whether they receive vet benefits and things like that, that's all there. Because if they do receive those, the other parties are required to get notice. Then who is the proposed conservatee? Are they adult? Are they a minor? Blah, blah, blah. And we then get into the reasons for why a conservatorship is needed in section 5. These are the spots for you to make an argument. Why is a conservatorship of the person necessary? Why is a conservatorship of the estate necessary?
That's just the petition piece. So you're
Okay,
good.
I still have a little bit more.
Oh, you do? Okay.
Yeah. There's a whole section regarding declaring whether you're a spouse, domestic partner, and things like that. Again, the court is looking for potential conflicts of interest. So you do have to make those declarations. There's a section regarding what medical care are they receiving or will they receive. So it talks about the capacity declaration. Something interesting here is there is a specific section to indicate whether the conservatee is, quote, an adherent of a religion that relies on prayer only for healing, as defined by the probate code section. That's meant to protect their religious beliefs, right? So if that's what they believe, that is what the conservator has to follow. Lastly, on the last page, there's whether you filed a temporary conservatorship and then who the relatives are, right? You have to give that information to the court so they can double check if you've sent notice to the right parties. My main practice pointer on all of these on the forms is really to read it in detail every time and to answer each question as you go and not to try to go through it as quickly as possible. It takes a lot of time to complete this. Just to give everybody a sense, if I'm working on a set of conservatorship documents, I set aside at least a half day, right? So you're looking at a minimum of 3 to 4 hours to complete the documents to get them done well. Otherwise, if you don't get them done well, you're coming back and dealing with it later. So you're just pushing the time back, right?
Thank
All right,
you.
and I think that's it for those of you online. Thank you. And if you guys have any more questions, I'm happy to answer them. Yeah. Yeah, for everybody else, if you want to disperse, that's fine as well. I don't care.
Regarding to refugees, to courts tend to grant good cause if you apply for it, someone they could please do really all. They're back
Grant good cause for what?
for the lack of notice to the service.
No, the conservatee is always going to be required to get those. Yeah, whether that be through their attorney or personally to the conservatee themselves, because you're taking away their rights, the court is always going to require notice. If it's a relative that's taking advantage of them, the court's much more willing to let go of notice on that. Or if it's a child that's disappeared, we have no idea where they are, right? The court's willing to let that go. But for a person themselves, no, that's not going to go away. Any other questions? Yeah.
Do you have to put on a petition or request for an attorney's fees, or is that just something that gets done with the county?
You do have to petition. Attorneys have the rights to petition for their fees. If you don't get paid. You can be paid from a third-party source. So if mom is hiring a professional fiduciary, I would potentially charge mom directly if I'm representing mom. Professional fiduciary would be represented by separate counsel later on, and they would petition for their fees out of the conservatorship. Right. For most professional fiduciaries, they won't take the case if there's no money involved.
Right.
Yeah, because they can't get paid. There are a handful that will do things pro bono, but there's not that many.
I have one more question, sorry. How do, counsel for the conservatee and the court investigator, is that something like you have to do with that state court?
In most counties, the court investigator is automatic. But there is the ability on the petition. On the petition for conservatorship, and there's a separate form to request an appointment of a court investigator if it doesn't get done. For court appointed counsel, it is automatic again for most counties, but I showed you the form for a petition to appoint. We do it just to speed up the process. I don't want the attorney to get appointed with 10 days before the hearing, and they come in and say, I haven't had the chance to meet with my client, we need a continuance. Right, I want it done in 1 year.
In that case, would a temporary be extended to the new hearing date, is that?
If the court thinks it's necessary, then yes. Yeah. Yeah,
Regarding the religious provision, have you ever come up with a problem when you're part of a cult?
no, I have not. I can see that being a potential issue, but no, it hasn't. I think that is a point of litigation if it ever comes up. Yeah, I could see Scientology being an issue for that. Yeah, Jehovah's Witness is the main one where that's designed for. Right, so I don't think that would be a question. Yeah. Yeah. So Jared wants it. Let me see, does anybody else have any general questions?
What are you gonna do about guardian?
I'm not.